Welcome to the Mandamus Lawyers Podcast, a legal education series about federal court remedies for immigration delays. I'm Mary, and I'm here with my co-host, Aaron. Today, we're discussing what happens after you file a mandamus lawsuit, specifically how the government responds and the potential outcomes of these cases.
In Episode 6, we walked through the process of filing a mandamus complaint and serving the defendants. Today, we're picking up where that left off. Once the government is served, the litigation enters a new phase, and there are several different directions the case can take.
So let's start with what happens immediately after service.
Once the complaint and summons are properly served on all defendants, the clock starts running. The government has 60 days to respond, longer than the standard 21 days for private parties because federal defendants receive additional time under the rules.
Who handles the case on the government's side?
The case gets assigned to an Assistant United States Attorney in the district where the lawsuit was filed. The AUSA is the lawyer who will represent all the federal defendants, USCIS, the Department of Homeland Security, the Attorney General, and the individual officials named in the complaint.
What does the AUSA do first?
The AUSA contacts the relevant agency, usually USCIS, to get information about the case. They request the administrative file, ask about the status of the application, and find out why there has been a delay. This is often the first time anyone at the agency takes a hard look at why this particular application has been sitting without action.
So the lawsuit itself creates accountability.
It does. Before the lawsuit, the application may have been one of thousands in a backlog with no individual attention. After the lawsuit, someone at USCIS has to explain to a federal attorney why this case has been delayed, and that attorney has to decide how to defend the delay in court.
What happens in many cases at this stage?
In a significant number of cases, the agency adjudicates the application before the government even files its response. The AUSA contacts USCIS. USCIS pulls the file, reviews it, and issues a decision, all within that initial 60-day window.
So the lawsuit achieves its goal without any court ruling.
Exactly. The purpose of a mandamus lawsuit is to compel a decision. And if the agency makes a decision after the lawsuit is filed, the case has served its purpose. The plaintiff got what they were asking for, agency action.
What happens to the lawsuit at that point?
If the agency approved the application, the case typically gets dismissed as moot. The plaintiff no longer needs the court to compel action because the action has already been taken. The parties usually file a joint stipulation of dismissal.
What if the agency denies the application?
The mandamus case is still moot because the agency has acted. Remember, mandamus compels a decision, not a favorable decision. If the application is denied, the plaintiff may have other remedies to challenge the denial, such as an administrative appeal or a separate lawsuit challenging the merits of the denial. But the delay case is over.
What if the agency doesn't act during those initial 60 days?
Then, the government must file a response to the complaint. One option is to file an answer. An answer is a document that responds to each allegation in the complaint, admitting some, denying others, and asserting any affirmative defenses.
What kind of defenses does the government raise?
Common defenses include that the delay is not unreasonable under the TRAC factors, that the agency is processing cases in the order received, that national security or background check procedures justify the delay, or that the court lacks jurisdiction for some reason.
If the government files an answer, what happens next?
The case moves into the discovery and briefing phase. The parties may exchange information, file motions, and eventually the court will decide whether the delay is unreasonable and whether to order the agency to act.
You mentioned the government can also file a motion to dismiss.
Yes, and this is actually more common than filing an answer in mandamus cases. A motion to dismiss argues that even if everything in the complaint is true, the case should be thrown out for legal reasons.
What arguments does the government make in these motions?
Several common arguments. First, the government may argue that the court lacks subject matter jurisdiction, meaning the court doesn't have authority to hear this type of case. Second, the government may argue that the plaintiff has failed to state a claim, meaning even accepting all the facts as true, the delay isn't unreasonable as a matter of law.
Are there other arguments?
Yes, the government sometimes argues that the case isn't ripe, meaning it's too early to sue because the agency is still actively working on the application. Or the government may argue that the plaintiff hasn't exhausted administrative remedies, though this argument has limited applicability in delay cases.
How do courts rule on these motions?
It varies. Some motions to dismiss are granted and the case ends. Others are denied and the case proceeds. Sometimes courts grant the motion in part and deny it in part. The outcome depends on the specific facts of the case and how the court applies the TRAC factors.
Do these cases ever settle?
Yes, settlement is another common outcome. At various points in the litigation, after the complaint is filed, after the government responds, or even after briefing on motions, the parties may negotiate a resolution.
What does settlement look like in a mandamus case?
Typically, the government agrees to adjudicate the application within a specified time frame in exchange for the plaintiff dismissing the lawsuit. For example, the government might commit to issuing a decision within 60 or 90 days.
Is that commitment enforceable?
It depends on how the settlement is structured. If the agreement is put on the record with the court or incorporated into a court order, there's a mechanism for enforcement. If it's just an informal agreement, the plaintiff has to trust that the government will follow through, though they could always refile if the government doesn't honor the commitment.
Why would the government agree to settle?
Litigation costs time and resources. If the agency can resolve the case by simply adjudicating the application, which it should have done anyway, that's often preferable to continuing to defend a lawsuit. The AUSA may also recognize that the delay is difficult to defend and advise the agency to act rather than risk an adverse court ruling.
What if the case doesn't settle and doesn't get dismissed? What happens if the plaintiff wins?
If the court finds that the delay is unreasonable, it will issue an order compelling the agency to act. This is the relief the plaintiff sought when filing the lawsuit.
What does that order look like?
The court typically orders the agency to adjudicate the application within a specified period, often 30, 60, or 90 days. The order may also declare that the delay was unlawful and unreasonable.
Can the agency appeal?
The government can appeal, but it rarely does in these cases. Appealing would further delay the case and cost additional resources, and the government would still eventually have to adjudicate the application. In most situations, it makes more sense for the agency to simply comply with the court's order.
What if the agency doesn't comply with the order?
Failure to comply with a federal court order can result in contempt proceedings. Courts have tools to enforce their orders, and agencies generally take court deadlines seriously. Non-compliance is rare.
Let's talk about the less favorable outcome. What happens if the court grants the government's motion to dismiss?
If the motion to dismiss is granted, the case is over, at least at the district court level. The court has determined that the plaintiff is not entitled to relief, either because the court lacks jurisdiction or because the delay is not unreasonable as a matter of law.
Can the plaintiff appeal?
Yes, a dismissal is a final order that can be appealed to the Circuit Court of Appeals. The plaintiff would need to evaluate whether the district court made a legal error and whether an appeal is worth the time and expense.
What factors go into that decision?
The strength of the legal arguments, the cost of the appeal, how much longer the application has been pending since the lawsuit was filed, and whether circumstances have changed. Sometimes, by the time an appeal would be decided, the agency has acted anyway, making the appeal moot.
Do mandamus cases ever go to trial?
Rarely. Most mandamus cases are decided on the briefs, meaning the court rules based on the written arguments and evidence submitted by the parties, without a full trial.
Why is trial uncommon?
Because the key issues are usually legal, rather than factual. The facts, how long the application has been pending, what the applicant submitted, what the agency has or hasn't done, are typically not in dispute. The question is whether those undisputed facts establish an unreasonable delay under the TRAC factors, and that's a legal determination the court can make without witness testimony.
Are there exceptions?
Occasionally, if there are disputed facts, for example, about whether the agency acted in bad faith or whether the applicant caused some of the delay, the court might need an evidentiary hearing. But this is uncommon. The vast majority of mandamus cases resolve through dismissal, settlement, or summary judgment without a trial.
How long does all of this take?
It varies significantly depending on the court's docket, the government's response, and whether the case settles. Some cases resolve within a few months of filing. The agency acts quickly after being served, and the case is dismissed. Others take a year or more if there's contested motion practice.
What should applicants realistically expect?
They should expect that filing the lawsuit will likely get attention on their case. In many instances, that attention results in a decision relatively quickly. But they should also be prepared for the possibility that the government will fight the case, and litigation can be a slower process. The outcome is never guaranteed, but the lawsuit puts the applicant in a much stronger position than simply continuing to wait.
Let's summarize the key points from this episode.
First, after a mandamus lawsuit is served, the case is assigned to an Assistant U.S. attorney who contacts the agency. In many cases, this attention results in the agency adjudicating the application before the government even files a response, and the case is dismissed as moot because the plaintiff received what they sought, a decision.
Second, if the agency doesn't act promptly, the government will file either an answer or a motion to dismiss. Motions to dismiss commonly argue that the delay is reasonable under the TRAC factors or that the court lacks jurisdiction. Cases may also settle, with the government agreeing to adjudicate within a specified time frame in exchange for dismissal of the lawsuit.
Third, if the case proceeds to a decision, the court may grant the motion to dismiss, ending the case, or rule in the plaintiff's favor and order the agency to act within a set deadline. Trials are rare because most issues are resolved on the written record. Throughout the process, the lawsuit creates accountability and pressure that often leads to resolution even without a final court ruling.
Thank you for listening to the Mandamus Lawyers podcast. Mandamus Lawyers is a law firm focused exclusively on federal court litigation for immigration delays. Visit mandamuslawyers.com.